Today we're talking about two different crimes that are housed under the same statute. One is having an open container of alcohol in your vehicle. The other is consuming alcohol in your vehicle. Whether it's your vehicle or you're a passenger in the vehicle, it's consuming alcohol in a motor vehicle or having an open container of alcohol within the passenger compartment. They're both housed in Title IV under Section 42-51. And the law is written here in red. We'll run through it. We're going to talk about the penalties, and we're going to talk about some common outcomes, some defenses that you may have if you've been charged with one of these two crimes. So the first and foremost is it's unlawful to consume alcohol if you're operating a motor vehicle or if you're a passenger within the motor vehicle. It says passenger compartment. So that's going to mean if you're in the passenger seat, in the back seat. Some people will do this while they're taking long road trips. They'll bring some alcohol. The people who are not driving the car obviously will have some drinks to help pass the time and have some fun on the road trip. If you're stopped and an officer sees that, they can cite you for having an open container or consuming alcohol within the motor vehicle. It's something that is actually quite common. Similarly, it's also a crime to just simply possess an open container of alcohol within the motor vehicle, within the passenger compartment area. So if you have an open container of alcohol, it's within the passenger compartment, meaning it's on the passenger seat or it's behind you. It's easily accessible. You can reach it, you can get to it, and it's open, the seal's broken, it's closed, but it's not sealed. That can be a crime. If it's in the trunk or if it's somewhere where you cannot readily access it, then that's not going to be a crime. It needs to be within the passenger compartment. So one of these two things can be a crime. Both of them can be a crime. Obviously, if you're consuming alcohol, you're probably also in possession of that alcohol. And so sometimes we'll see both of these charged under subsection 1 and 2 or A and B. So this is how the law works. It's pretty simple. Either you're consuming it or you are possessing it. You don't have to be intoxicated. It's not like a DUI. You can imagine that if you're stopped and you're consuming alcohol, they're probably going to be processing you for a DUI, but you don't have to be don't actually have to be impaired or under the influence of alcohol. If you've just taken a sip of something, they can charge you with the consumption and the possession. Both of these offenses are Class 2 misdemeanors in Arizona. So Arizona operates on a scale. We have Class 1, 2, and 3 misdemeanors. Class 1 is the most serious. Class 3 is the least serious. Class 2 is right in the middle. The maximum penalties for a Class 2 misdemeanor: 4 months of jail, 2 years probation, $750 in fines. They can tack on a bunch of surcharges as well, depending on what jurisdiction you're in. So as you can see, it's a fairly serious charge. Anything that's involving alcohol that goes on your record, employers, job applications, things like that, when they do a background check and they see that, they may have concerns about it. So you want to make sure that you're not ending up convicted of this. Now, I said 4 months jail. Doesn't mean you're going to get 4 months jail. That's the maximum penalty. We very rarely see anybody get the maximum for something like this, but it is a legal possibility. More realistically, it's probably just going to be some fines, maybe a small amount of probation, maybe some alcohol classes and those things. If you plead guilty, of course, we want to avoid that. How do you do that? So some common outcomes are we want to try to reduce the criminal charges into civil charges. In Arizona, there are sort of civil analogs. So you can say that the vehicle had something in the vehicle that was not proper. They're kind of like equipment violations. The vehicle contained something that it should not have contained. And so you can make the same factual basis for this. So under the criminal code, it's, yes, the vehicle contained alcohol. There was consumption of alcohol within the vehicle. There was a bottle of alcohol. There were bottles of alcohol. When you drop it down to a civil, you can say the vehicle contained improper equipment, improper items were within the vehicle. It's a civil violation, but you can say, okay, the alcohol was improper. It shouldn't have been in there, but you drop it from a criminal into a civil. That way you're not having a criminal conviction. And that's really what most people are concerned about when they are facing these charges. Also, in some jurisdictions, it depends on the city, it depends on the court, it depends on the prosecutors, you can get what's called deferred prosecution or diversion. Deferred prosecution means that the prosecutor's office will hang on to the charges. So they'll kind of, while your case is being prosecuted, they'll stop it, they'll set it aside, they'll say, we're going to look at your record again in 6 months or 1 year. If you've been convicted of anything else, we're going to bring those charges back. But if you haven't, and you want to pay a prosecution fine, you want to pay some certain fees and processing things, they'll dismiss those charges. That's called deferred prosecution. Diversion is where you do something in exchange for a more immediate dismissal. So you take an alcohol class, you take a substance abuse class, you take a DUI class to show you about the risks of drinking alcohol in a motor vehicle. You do something, and in exchange for doing that, they turn around and dismiss the charges. That's also something that can be negotiated out. If you can't reach something, you can't reach a reduction, or you can't get something negotiated, sometimes these cases have to go to trial. Sometimes the person who was driving the car is cited, but it wasn't their bottle. It was their passenger's bottle. And so it's hard to kind of make the connection that that person should have criminal culpability when really they weren't in actual possession. They weren't consuming, they weren't in actual possession. That may be the case. So there's a lot of different factual issues that can arise in these things. You want to make sure that you are taking it seriously. As I said, it's a Class 2 misdemeanor. Arizona, we don't have anything like expungement. So if this goes on your record, it's going to be staying there. We do have what's called a motion to set aside your conviction, but it's a lot less powerful than what you might think of in terms of expungement. So you want to, at the outset, make sure that this is being dealt with properly. Our office, we've got a criminal defense team. That's all that we do. We only focus on criminal law. We make sure that we meet with you, put together a very solid plan so that you are not having to face a criminal conviction as a result of any one of these violations. If you do have these charges pending, give us a call. We offer free case evaluations. We'll schedule an appointment to meet with you. I look forward to speaking with you soon. Thanks for watching.